Okay, the next item on the agenda is old business. We previously held public meeting, and now we need to finish up that. We postponed the decision from last month's meeting until tonight. Mr. Petty, do you help us introduce that?
Yeah, so again, we are here to further the discussion. As you said, the public hearing has closed, and it is for BZA 2019-0601 Nelson Mendes, an appeal of the determination by the Warren County Deputy Zoning Administrator given on May 1st, 2019 to Nelson Mendes. The determination was that given the information obtained by the Planning Department for an agricultural exemption application, the zoning application would not be approved as submitted. All structures, which include 2 metal buildings, 1 hoop greenhouse, and 1 deck, require a zoning permit and must meet all other applicable codes and ordinances, such as the Virginia Uniform Statewide Building Code, to ensure that they meet the requirements for floodproofing as described in the federal guidelines. These requirements are addressed in Warren County Code Section 180-16F1A and noted in the determination and a previously communicated violation. The property is identified as Tax Map 36C, Section 3, Block 2, Lot 14, and located at 0 Stoney Bottom Road in Front Royal, Virginia. Is part of the Haynes-Anderson Thunderbird subdivision and is zoned agricultural.
Okay.
I did just want to mention that you have 2 documents. One is a memo. I apologize for not getting it to you a little sooner. The planning department did put this together, but our email has been down for the last day and wanted to get it out earlier. Unfortunately, I was unable to do that. I was able to talk to the applicant's legal representative today about it, and then was able to email it out later. But that is here in front of you. It is revised recommendations to the applicant. There's also an email that we received this afternoon from a Mr. Kirby stating there's support for Mr. Mendes and any legal documents there. I will say too that we did talk to Mr. Johnson, and he spoke to his client about the memo, and they said, I believe, thanks but no thanks, and that they would, like to hear the BZA's decision this evening on the determination. So.
Okay, can you kind of go through that a little bit with me? It looks, it's a little confusing for me. So you're saying
the memo
that we got today?
Yeah, so last month, after there was no ruling, that we were tasked to think of possible solutions. We did discuss them, but again, we were reading the code and we're trying to follow a strict interpretation of the code there. In discussion with colleagues and going back and reading the statement of justification from the applicant, we came up with these recommendations. We feel that they meet the intent of 180-16 in the fact that the planning department would be able to have documentation of these, and it would meet FEMA's recommendations. Obviously, these recommendations do not prohibit any other department in their authorization of requirements and stuff, but this would meet the planning departments. The first one was that we would approve the agricultural exemption that was submitted on April 22nd for the 2 metal buildings and the hoop house. We would accept those applications and sign those. We probably would ask for just a little bit more information. We do have a lot of information. I had Mr. Winland go through those. I have all that information here. They provided photographs. We've done site visits. There's just, I think there was just some anchoring things. We would just want photographs or some specifications to go with that, with the flood vent information we have. So we would ask for that, but they would be approved. We also, and then we said that the deck structure would be approved for agricultural use because it's a recreational use in the eyes of the zoning office. And that would just require a standard zoning application. That standard zoning application does come with a $10 fee that we would accept. And then we would ultimately approve that. We have sufficient enough information from the site visits and the statement of justification, the description, and the photographs, enough for that for the zoning office to approve. We would put all that in a file, and that would, we could send it if FEMA ever questioned. We would say we had, an approved ag exemption. And again, yeah, these would be filed for any future floodplain reviews from our staff or FEMA. And in addition to that, we had to think a lot more about how this plays into 180.16, and we would look at that a little bit differently in how we address agricultural, recreational, residential structures. And the planning department would probably end up tasking the planning commission to rethink some of that ordinance and make some amendments to that given this case. And we would also look at how we approach any accessory structure in the future to kind of help avoid a situation like this, and maybe that's requiring a zoning permit for any shed, whether it's in a floodplain or not, just to make sure that nobody is confused. At least we can determine whether you need one or not if everybody knows that you're going to at least have to apply for one. So we're going to explore those options, and we might be going to the planning commission to take a look at that.
All right, so that doesn't, the planning department would go ahead and sign off on the agricultural exemption.
Correct. Well, this is what we talked to their legal representative about today. Again, I understand it was kind of last minute, but we did talk to them, and again, they were not in agreement with these recommendations and wanted to hear the BZA's decision this evening.
You guys have any questions?
No.
No, I think they pretty much explained it.
With all due respect, maybe we have an opportunity to put in a response to the memorandum.
The public hearing was closed last month, and it's really open for us to make a decision. We just need to discuss and make a decision unless you guys have a specific question for the applicant.
With all due respect, Mr. Petty is going to place a new memo in there with new recommendations at the 11th hour and claim that we're in disagreement with it without at least giving us an opportunity to explain our position, why we're in disagreement with it. I think it would be appropriate if we may.
I mean, if we have a question about that, if you want to ask why they disagree with the recommendation, it's perfectly fine. They are allowed to answer questions.
What I would ask is, what would it take? What would it take to get this further for you to agree?
We're not trying to be obstructionists, to be clear here. The concern we have, more than anything else, is the fact that this proposal is coming in at the 11th hour, at the last minute. Particularly, this is what we've been asking for since day one. This is the problem, and there's a reason why we need to take a stand against the fact that we now suddenly need to comply with everything that we've said we wanted from day one, and expect that the BZA would basically rubber stamp the planning department's decision to come 95% of the way. The last 5% though is what matters. That's the difference between the touchdown versus end of the game. It's that my client has spent more than $10,000 at least in legal fees trying to get the planning department to this position of understanding that what my client has alleged all along was right, or the vast majority of it was correct. And to say now, after we've done all this, that we'll rubber stamp saying that the planning department has come that way, without the BZA coming back and saying that the original agricultural exemption application should have been granted in the first place, without the residential building permit requirements, and without coming all that way, it's just, it adds insult to injury, to be honest with you. And I understand from your position, you have a decision to make as to whether you're going to suddenly agree with the zoning administrator's position here at the last second. But this is what we've asked for all along. If anything, it should be overturned and just you finding for yourselves that the misconduct that has been engaged in by the planning department warrants an overturning of their original decision as well as in this memo, and finding that my client has nothing further to do with what has occurred. That he's in full compliance at this point. At this point. That there's nothing else for him to do. And that's essentially what the planning department is saying. There is nothing else for him to do but pay a $10 variance fee. Oh, I'm sorry, a $10 zoning permit fee. It's, to me, it's just, that's the insult. That he's gone all this way. He's been saying this all along. And now we're here, we're gonna ask for that. That's my position as to why.
I'd like for you to, I'd like for you to.
My client has been wanting to fully tell this story. Anyway.
I think we can probably make a decision based on the information that we have. I understand your position. I understand that, you've gone to a lot of trouble and a lot of expense to fight this thing. I guess I have another question for our zoning department. In this memo, you're saying they do not have to do anything else because there are still FEMA flood requirements that I am not seeing satisfied here.
So we worked with colleagues, and Mr. Winling, our floodplain manager, is
Okay.
here to make sure that this would still meet FEMA's requirements.
So we could, it will be documentation to submit to FEMA.
It will be documentation, as in the first bullet, well, the subsequent bullet below that is, we would probably request just a little bit more on the anchoring part of it. We do have information, but, in the code it states that it's flood-proof, flood vents and anchoring. So I'm sure that the building is anchored in some way. Right now all we have is the flood vent part, and we would just want to just verify that.
So I don't know how the motion should go. I mean, because are you saying that we were wrong in our first assessment? Are we to determine that?
So I think the BZA's, we wrote this to address these recommendations, and obviously they have rejected our recommendations. It was what we thought that they wanted. It met the intent of the code, but our determination is, a strict interpretation of 180.16. Again, 180.16.1a states all uses, activities, and development occurring within the floodplain district shall be undertaken only upon the issuance of a zoning permit. This we feel like would issue that zoning permit. Our determination was that he would also require other permits, because like the Virginia Uniform Statewide Building Code, prior to the issuance of such permit, the zoning officer shall require all applications to include compliance with all other. We still feel like he still this meets the zoning. If he doesn't meet the other requirements, that's between him and the other agencies at this point. But I think
So
tonight
we
is
the motion
the BZA's ruling on the determination, not the memo.
on this determination.
I think that was the original determination. Yeah, I mean, unless you want to move forward with the memo, but they said that they would, like to hear your thoughts. And Ms. Logan.
We revisited this because the BZA asked us to go back and look at our processes.
Yes, we did last time.
Yeah, so we thought this was a good solution from the BZA's last meeting, asking us to look at our processes. So we thought this addressed the zoning part. But now you're to rule on the original determination.
So we have to rule on the original.
In which the ordinance, we feel that was correct and the way the ordinance reads. We just thought this was a good kind of compromise.
which again, with all due respect, the issue is that this was brought to our attention in the 11th hour. If this was brought earlier on, a week, maybe 2 weeks ago, especially before the supplemental staff report on August 29th was issued to us, I can understand us all trying to work this out and come to a compromise that would accommodate everybody. But it didn't happen. It's today.
Well,
And-
I think we have enough information. We're just gonna have to make a determination as to how we want to send this forward.
And again, I do object to not being able to put in the additional information that, most of what I would present tonight is based on what my supplemental statement of justification included. It does go into the conduct, because if the determination is going to be based on the original determination and we discover new information, the FOIAs, for example.
Well, we have to rule based on the information that we have and what we originally had to work with. So that's what our procedures require. So that's what we will do.
All right, I'm just noting it from our objection purposes that we did want to include additional information in that. That's not
That's
happening.
fine.
I understand, thank you.
May I speak?
No, I'm sorry. We don't have a public hearing. It was closed last time.
I'm not the public.
What do you think here, guys?
We discuss this among ourselves.
This is confusing.
I would ask that to the extent that there are any deliberations that are occurring, that they be held publicly, please. Thank you.
Just keep your microphones on.
You have to keep your microphones on.
Yeah, and turn that other one on there, Mr.
Yeah.
Wickham, and there's a second one there that you can turn on, the other one.
Or this one if you want to.
There you go, that way it'll carry.
It doesn't seem to me that the motions exactly fit. You know, if we wanted to send this forward based on the letter, it doesn't seem that they fit.
I think the verbal things we just heard, it overrides the one from floodplain manager to agree with that, so.
So. Are we allowed to make up our new motion? Do you have to?
We still have to do the same motion, wouldn't it, from last month? We still have to.
I mean, that's what we've got to work with.
Yeah, that's what you want to do.
Mr. Chairman, you can rule in full or in part of the determination too. You can make a motion. And you can, however you see fit. Feel
All
free.
right, well, you want to try to do a motion? Are you ready? What's your pleasure?
The thing to do is make a motion based on this information.
Okay.
If you want to do that.
I can.
Again, I would just like to request that we have an opportunity to go ahead and make our presentation, but if BZA is
I think
satisfied.
we're ready to.
Okay.
I think we're ready to move on.
Thank you.
I move that the Board of Zoning Appeals approve the appeal request of Nelson Mendes and overturn determination of the Deputy Zoning Administrator that the structure does not meet the requirement for agriculture exemption and requires permits based on a memo received by the zoning minister with revised requirements and meeting the requirements of a floodplain manager.
Could you repeat that, please? I didn't quite follow.
Excuse me? What?
You can repeat it, she wants
Yeah.
it repeated.
The whole thing again?
Yeah, it was the beginning. I wasn't sure what was being overturned.
I move that the Board of Zoning Appeals approve the appeal request of Nelson Mendes and overturn the determination of the Deputy Zoning Administrator that the structures do not meet the requirements for agriculture exemption and requires permits. Based on a memo received from the Zoning Administrator with revised requirements and on meeting the floodplain managers.
May I ask for one more piece of clarification? Is that determination indicating that there is nothing further for Mr. Mendes to do regarding the planning department's thing? Or are you asking that Mr. Mendes comply with the particulars of that memo in the provided by the planning department tonight? Because that would also require my client to provide additional information to the planning department as well as pay a $10.
Basically, what I'm saying is you have got the requirements of the zoning, but you have to meet the requirements of the floodplain and everything else.
You're not overturning it?
Again, I just want to be absolutely clear on that's all. Are we talking about then that whatever the memo states for requirements, $10 permit fee, that is what my client must comply with?
Right, and in the memo, there's a paragraph, however, zoning approval does not have any authority over any recommendation or requirements from other agencies or departments.
Okay, I understand that. And that's fine, we accept but object to that determination. We'll decide accordingly from there, but thank you.
Does he forward it? Yeah.
Second.
Can we verify that?
Okay.
Yes.
I have a motion and a second.
Any discussion?
Any discussion? Any further discussion here? Okay, you ready for a vote? All those in favor say aye.
Aye.
No? Any noes? Okay. All right, the motion is passed.
Yeah.
All right, thank you very much.
Thank you very much for your decision and time on this.
Anything else from staff?
Does any board member have any discussion, updates, or anything? We're still a member short. Fortunately, we were an extra member short this evening as Mr. Farron had a family that matter to deal with. We're still one member short of the BZA, and so if you know anybody in the North River District, we'd be happy to fill that vacancy. We will also likely see a few variance applications come through in October and possibly November for some of these FEMA requirements. As the folks, they want to get their building permits, but they may not meet the setback requirements. Some of the lots are pretty small along the river, and so they are going to be coming in, it sounds like, for some setback variances and yard placement variances. So be on the lookout for some agenda items coming up soon.
Okay. Ms. Logan, you have anything?
Yeah, ma'am.
Okay. Board members, you have anything else? Is there a motion for adjournment? Motion to adjourn?
Make a motion, we adjourn?
All those in favor say aye. Aye.
Aye.